that's true.
When Mike was here about a month ago, you all asked that he come back again and speak, so we worked out the dates. And so again, I would like to introduce a good friend of mine through the shrine, Judge Michael Wallach.
Thank you. There's nothing like being back by popular demand. Yeah, well, last time we talked about Shriners Hospitals for Children and all the good work that they do. And by the time we got finished, the hour was up, so we didn't have time to talk about the courts. How many of y'all are from Texas? All right. Don't have to give quite as much a history lesson there, but just to kind of put things in perspective. Of course, we turn that off. There we go. Back we just celebrated our independence in March and April from Mexico, 1836, and so from 1836 to 1845, Texas was an independent republic back in the good old days. In 1845, we became a state in the United States, and stayed until 1861 when Texas seceded as part of the Civil War, and in 1865 rejoined the Union, but under what was called Reconstruction, which was under the supervision of the United States government. We emerged from Reconstruction in 1875, and in 1876 Texas passed the Constitution for the state of Texas, which still exists today. It's been amended many times over the years as Texas has transitioned from a rural farming and ranching state to a predominantly urban state, and so as things have changed over time, it's been amended many times, but it's still the foundation from the 1876 Constitution. So up until 1891, Texas had two courts involving appeals, okay? So we'll talk in terms of two types of courts. And remember, we're not talking about the federal court system, which is the U.S. Supreme Court, the various courts of appeals, and the various trial courts in the federal court system. That's for a different day. I'm involved in the state court system, the state of Texas, okay? And so again, putting things into context, in 1891, one of those amendments to the Texas Constitution, it created what are called intermediate appeal courts, okay? So if you have the trial courts where you have jury trials and judge trials, and let's call that the entry-level courts to the system. In the old days, you had basically had the district courts, and the county judges actually had legal jurisdiction at that time, and today some of them still do. And if you had an appeal on the civil side, it went to the Texas Supreme Court. If you had an appeal on the criminal side, it went to the Court of Criminal Appeals, both of which were located in Austin. Because the workload was increasing, there was an amendment to the Texas Constitution which created the Courts of Civil Appeals, okay? And there were three of them. The first Court of Civil Appeals was in Galveston, which at that time was probably the largest center of trade and commerce in the state of Texas because of the port of Galveston. The second Court of Appeals was in Fort Worth. And the third Court of Appeals was in Austin, okay? And so I'm on the second Court of Appeals, which started doing business in Fort Worth, Texas in 1892, and we're still here today. Our jurisdiction, the area that we would hear appeals from the trial courts, was a little bigger in those days, because now we have 14 courts of appeal. In those days, like I said, we had 3. Okay, so our jurisdiction, if you kind of, started at the Louisiana border, drew a line through Waco all the way to the New Mexico border, everything north of that was ours. So things have changed a little bit. Now we have 12 counties. Okay, so if you start on I-35 in Fort Worth, in Tarrant County, you drive due north to the Red River. It takes you through Denton County and Cook County. Don't cross over the Red River, then that gets you in real trouble. Unless you're going to Windstar, of course. But turn left and go west to Wichita Falls, which is Wichita County, and then come south down through Young County, Jack County, Parker County, down to Granbury, which is Hood County, and come back to Fort Worth. It's kind of a triangle. That's our 12-county triangle, okay? And so if you have a case in setting aside the municipal, the city courts, okay? But if you're coming from county courts at law, county criminal courts, from the probate courts, from the district courts, if you have appeals from any of those cases, from any of those courts in that 12-county region, and I think there's 105 courts now that we take appeals from, that's what we do. And it's civil cases. So if the people fighting about property and money, okay, if it's family law, where it's things having to do with divorces, divorce settlements, child custody, or parental terminations, those all come to us. If anything having to do with criminal appeals, except the one big one that we don't handle are if someone is convicted in district court of a capital murder and they get the death penalty, we don't hear death penalties. Those go straight from the trial court to the Court of Criminal Appeals in Austin. Okay. Other than that, we hear virtually all criminal appeals, and if there are probate matters involving estates and administration of estates, that sort of thing, we hear those appeals. So that's kind of a wide variety of things that we take up on a daily basis. It's interesting because we have kind of a basic structure of trial courts, but it varies from county to county. So, for example, Tarrant County is your kind of typical large urban county. We have specialized courts, okay? So if you have matters having to do with probate, estates, estate administration, mental health, we have two probate courts, Probate Court 1 and Probate Court 2, okay? If you're dealing with felonies on the criminal side, those are all handled by the criminal district courts, okay? If you're talking about misdemeanors, Tarrant County has 10 misdemeanor courts. They're called the county criminal courts, and they handle things that the biggest single item on their docket is driving while intoxicated, driving under the influence. That's a huge portion of it. But they also have other things that they do as well. If you're talking civil cases, cases involving property and money, personal injuries, that sort of thing, the district court, which is a constitutionally created court, there are 10 civil district courts in Tarrant County. I used to be the judge of the 348th Civil District Court. And so it seems odd, but the minimum jurisdictional amount, again going back to 1876, is $500. Okay, which in 1876 was a lot of money. Nowadays it seems to be a whole lot less. But anything $500 and above, can be filed in district court. But we also have 3 county courts at law, okay, which are courts that are created by the legislature as opposed by the Constitution, okay. And so the county courts at law in Tarrant County have jurisdiction up to, I think it's $250,000 now. But if you have a case where you have more at stake than $250,000, then it's got to be in the district court. And so those are the trial courts that we hear appeals from. Now, what's the difference between the courts of appeal, like the Second Court of Appeals, and the Texas Supreme Court, or the Court of Criminal Appeals. And realize there are only 2 states in the entire country that have that separation at the top between the Supreme Court on the civil side and the criminal courts on the other side. Texas and Oklahoma. Only 2 states in the country that have that distinction. So, when a case is brought to us, if it's something that's within our jurisdiction, which most things are, okay? For example, if someone tried to appeal a death penalty case, we couldn't take that because we don't have jurisdiction over that. But most of the things that come to us, we have what we call subject matter jurisdiction of. Okay? So if people dot their I's and cross their T's and file their paperwork on time, and they have a judgment that we can hear an appeal from, we have to take it. Okay? We don't have discretion. So we're pretty much kind of all takers. If you get to the Supreme Court, or the Court of Criminal Appeals, they are what are called courts of discretionary jurisdiction. They get to pick and choose the cases that they want to hear. Okay? And so statistically, 90% or more of the cases, both civil and criminal, end at the Court of Appeals level. The Supreme Court and the Court of Criminal Appeals take 10% or less of the cases that try to come from the Court of Appeals to the Court of Criminal Appeals. Now, so I mentioned earlier, just as I forgot to kind of follow this through, but in 1891 is when the Court of Appeals, okay, was created, but we only had civil jurisdiction then. It wasn't until, I believe it was 1981, that the Court of Civil Appeals became the Court of Appeals and was given criminal jurisdiction on appeals as well as civil. So that was a change that occurred during my tenure, as a matter of fact. As a practical matter, if you have litigation, if you have a lawsuit and there's an appeal, the Court of Appeals is going to be, statistically, your court of last resort. And so that's one reason why who is on your Court of Appeals is very important, because it may be your last and best chance if you don't like what happened in the trial court. So you got a slight chance of getting to the Supreme Court or the Court of Criminal Appeals, but it doesn't happen very often. You got to have some important issues, and that's what the Supreme Court and the Court of Criminal Appeals look to. They see their job as trying to determine what parts of the law need to be defined better. Okay, and so if there's for example, if there's a statute and there is an issue as to what types of transactions fall under that statute, you may have 3 courts of appeal saying these situations do. You may have 4 courts of appeal which disagree with that and say no, they don't. And so one of the ways you get to the Supreme Court is if there's a disagreement between the courts of appeals on that particular point. Okay, and so that's their job, is to kind of supervise the development of the law so that people can find continuity and similarity across. Now, you say, well, how can you have 3 courts of appeal saying one thing and 4 courts of appeal saying something else? It's real simple. Within our geographical jurisdiction, we are the court of last resort unless the Supreme Court says something else. Okay? So it may be that we interpret the law a particular way, and the Dallas Court of Appeals may say, we disagree with the Fort Worth Court of Appeals. That's their prerogative. So that's how you wind up sometimes with some differences between the courts of appeal, is that you just have differences of opinion as to how the law should be interpreted or how it should be applied. So who makes up the courts? The sizes of the courts vary, as you might expect. In the rural courts, for example, in Eastland or Tyler or Texarkana or Amarillo, they have 3 judges. That's your basic number, is a 3-judge court. Okay? And they go up from there depending upon the workload of the courts. We have 7 justices on our court. I think Dallas has 11, and in fact Houston actually has 2 courts of appeal. Remember, I told you back in 1891 the first court of appeals was put in Galveston. Well, I think it was 1914 they moved it from Galveston to Houston, and then back in the 60s the load in Houston was so big that they actually created the 14th Court of Appeals and put it in Houston too. So Houston actually, Harris County and the surrounding counties actually have 2 courts, the first and the 14th. That's the first and the last. And that's created some issues over the years. I think they've worked hard to try to synchronize the way they work, but sometimes they still go different directions. But the justices, okay, we have 7 justices, and we're all elected, okay, and we're elected by the voters in those 12 counties that we serve, okay. So being elected is how you stay on the court. How you get on the court initially either can be an election. For example, if someone decides not to run for re-election, okay, the governor may choose not to appoint somebody, and so then that's called an open seat, and people file and they run for it. You file as a Republican, you file as a Democrat, you go through the primaries, then you go through the general election. Or the other way is if you have a vacancy between elections, the governor can appoint somebody to that seat, okay, which is how I initially got on the Court of Appeals. My predecessor was appointed to the federal court in Fort Worth, and so then Governor Abbott appointed me to take his position. So I then had to run at the next general election, and what I was running to do was to finish out his unexpired term. And so he had 4 years left, so I had to run for the final 4 years of his term, when actually the full term is 6 years. So that's how you get on the Court of Appeals. Some people who are on the Court of Appeals are former trial court judges. I'm a former trial court judge. Justice Birdwell was trial court judge. The Chief Justice Bonnie Sudderth was a district court judge. The other judges were not district court judges. They were appellate practitioners who wanted to go on the court. Now, what's an appellate practitioner? It's someone who spends most of their practice handling appeals of cases to either the Court of Appeals or the Texas Supreme Court, or on the federal side, usually to the Fifth Circuit Court of Appeals, which is in New Orleans. Texas, Louisiana, Mississippi are in the Fifth Circuit. So again, that's the federal stuff. We'll try to stay away from that. But those people who practice appellate law, generally the ones who want to be on the appellate court. Sometimes, you don't have to be an appellate lawyer or a trial judge to be on the Court of Appeals. If you have the requisite number of years of practice of law, that's all it takes if you can get elected to be there. Now, how do we handle cases? Well, in the trial court, okay, going back to the entry-level courts, you get one judge, okay, and he or she makes the decisions. and they're kind of the king of their fiefdom, okay? And they run their courts pretty much the way they want to. They set schedules the way they want to. They handle trials and hearings when and how they want to, and so they have a lot of independence because there's just the one of them. On the Court of Appeals, we hear cases in what are called 3-judge panels. So when a case, and it's kind of a series of moving wheels that we work from. And it's constantly changing during the course of the year. So the panel, what we call Panel A and Panel B, okay, which is cases that are assigned and are going to have, that are eligible for oral argument, okay. They don't always have oral argument, but they're eligible for it, are assigned to the Panel A and Panel B. And those panels are constantly changing throughout the year because the idea is we don't want the same panel of 3 judges working all the cases all the time. We have obviously different approaches to decision making. We have different philosophies within a certain realm, and we want to have a balanced approach to the workload of the justices. So we constantly rotate the panels for those cases, and all of the cases that go to those panels are assigned on a random basis. So it's not like, Judge Wallach is the expert in this area, and so he gets these cases, and Judge Birdwell is the expert on these things, so he gets those cases. And there's, the rationale is each of us brings our own experience and expertise to the court, but we don't want our area of expertise to be what dominates our decisions, because we want everybody to bring their own expertise to the table, because sometimes, for example, I spent 37 years, most of 37 years, representing doctors and healthcare providers who got sued for malpractice. You don't want that background to create some type of implicit bias in the decisions that come from the court. And so by continually bringing people in and bringing people out, we balance out that background influence so that everybody has a chance to say, no, wait a minute, I don't think that's right. Okay, so make sure that we have a balanced viewpoint of what we're looking at. There are, trying to think how the best way to explain this is. You start with the basic rule that in order to bring a case to our court on appeal, you have to have a final judgment. Okay? In other words, the trial court has made its final ruling, it's over, and now it's time for the Court of Appeals to take a look at it. Okay? And that's because, from an efficiency standpoint, you can't have the courts of appeal trying to micromanage what goes on in the trial courts. That creates problems. On the other hand, the legislature, God bless them, has in their wisdom created certain cases, what are called interlocutory appeals, which means appeals from the trial court on particular issues before a final judgment. Okay? For example, how many of you have heard of an injunction? Okay. Typically, that's where somebody is doing something that somebody else thinks they shouldn't be doing, and they're filing suit to stop it. Okay? And so you have your first step, which is called a temporary restraining order, which is kind of an emergency ruling by the trial court, okay, to either make them stop it or not. But that only lasts a few days. We don't ever hear those at all. That's not our jurisdiction. But the next step is what's called a temporary injunction, which generally means that while the case is pending, okay, we're going to tell you that you need to stop it. Now, we don't know if that's where we're going to wind up in the end, but just to maintain what's called the status quo, we're going to say stop that. Okay? For example, a lot of what you see in the trial court is where you have an employee, okay, who signed a non-compete agreement with their employer, and they say, okay, we're going to go to work for you, and we're going to agree that if our employment stops, that for 2 years after I quit working for you, I'm not going to try to come back and take the customers. That's a non-compete agreement. Well, there are certain rules about what non-compete agreements are enforceable and which ones aren't enforceable. And so that's where you get a lot of litigation on the temporary injunctions there. Well, one of those interlocutory appeals is that if someone wants to appeal from the ruling on the temporary injunction, okay, so if the trial court says, you need to stop doing what you're doing, Mr. Former Employee and new employer, you need to quit that. Okay? Well, if they don't like that, they can take an appeal of that ruling on that temporary injunction. So there's no final judgment yet, okay? But that one issue can be brought to us for review to determine whether or not the judge properly made a ruling on the temporary injunction. And it seems like, every few years the legislature keeps expanding the number of things that people can take those interlocutory appeals on, and so it just that's their prerogative. They're the legislature. They can do that if they want to, but that's where we see an increasing amount of workload in terms of cases which are coming to us that don't have a final judgment. So back to how we handle cases. So let's say that I'm on panel A this week, okay? About 3 or 4 weeks ago, I got my list of cases that were going to be submitted for argument next week on panel A, which is the morning arguments, okay? So I had a chance to start reading all the stuff that was filed. And what do we read? Well, the record from the trial court, okay? That's where we start. You have 2 parts of the record that come to you from the trial court to be looked at. We have the clerk's record, okay? And the clerk's record are the written filings that people filed with the clerk of the court. The lawsuit papers, the motions, the responses, all of the written stuff. It used to be written, now it's all electronic. Which really, it's amazing what difference that makes in terms of the way we physically handle our workload. But be that as it may, what else do we have to get to review? Well, the party bringing the appeal is typically called the appellant. And they will file the appellant's brief. And they will, there are certain things that they have to put in their brief, but basically it tells us who the parties are, who represents them, why we have jurisdiction. It tells us the thumbnail sketch of the case, and then it tells us what it is they're complaining about. Okay, their points on appeal, their issues on appeal. Then it tells that then they take those facts, okay, and they say, okay, the law is this, okay, and these cases or these statutes say this is what the law is, and given these are the facts, this is how the trial court made a mistake doing whatever it did. then the party who's responding is typically called the appellee, okay, or appellee, as some people would call it. And they file their appellee's brief. And it says, well, you know, we either agree with their version of the facts or we don't, and here's how we disagree. Okay, brief. Then the appellant, okay, since it's their burden to try to convince us, they get to file their reply brief and say, well, you know, we disagree with what the appellee said about what we said, okay, either on the law or on the facts or some combination. So we then take all of that information, we go out and we do our own, we read their cases, okay, we look at what they say about the record says about the facts, okay, to see whether or not what they say is correct or whether it's accurate or whether they're trying to pull the wool over our eyes. And believe it or not, that happens. So, you know, we have to read everything with an unbiased look to make sure that the parties are shooting straight with us on the facts, and then whether or not the cases, for example, they may say a case stands for proposition X, and maybe it does, maybe it doesn't, okay? So we have to analyze that, and then we also go do our own research, okay, to find out whether or not they've cited all the law to us, okay? Because believe it or not, there's a lot of cases out there these days, and you know, you've probably seen pictures of people standing by law books, okay? We don't use those law books anymore, okay? Now we use computerized research, and it's like everything else. When you're trying to find something in a computer, you got to ask it the right question, because if your question isn't phrased exactly right, then the cases that you're trying to find may not pop up. So you have to, it's called a query, and so you have to kind of, you know, play around with your queries and make sure that you're finding the right stuff, okay? And so sometimes the lawyers don't find the right stuff, okay? It's you know, it's an evolving skill, I guess is the best way to put it, and the amount of time that you put into it is sometimes it's important, sometimes it's less important, depending on how good your skill is in terms of writing the queries. But that's part of our job, is to make sure that they have brought us all of the law which is applicable to the decision that we have to make. And so once we have read everything that they've brought to us, once we've done our own research, each case, so we have 3 judges on panel A, for example. One of the judges among those 3 is what's called is assigned as the quote presumptive author, okay? And so if I'm the presumptive author, okay, I've gone in here and researched all this stuff, and so then we go into the courtroom, okay, and we have oral argument. Each side gets 20 minutes to give us their best shot. Sometimes they get to talk a lot. Sometimes we have so many questions they never get to say anything they want to say. So it depends on whether you have a hot panel, as we call it. And but after we have the oral argument, or if we don't have oral argument, sometimes we decide the cases. We just read all the stuff. And it's the type of case that we don't think the oral argument's going to add anything to it, so we don't have oral argument. We meet together as a panel, and we have our staff attorneys with us, and we go in there and we have discussions around the table. And so if I'm the presumptive author, I go in and say, this is what the case is about. This is the law, and this is how I think the case needs to be decided. And then each of the other 2 judges says what they think, and if we all agree, okay, then I write the first draft of the opinion. If we disagree, then it depends on how we disagree. If 2 of them think it ought to be one way and one thinks it ought to be the other, then the presumptive author is no longer the presumptive author, and one of those 2 becomes the presumptive author. And they either agree on it or they draw straws. And in a very rare occasion, you will have 3 judges who have 3 different opinions, And then it gets really interesting. I've only had that happen once. It's in the last 3.5 years, but it was a case where we'd had a previous panel had decided the case. It had gone up to the Court of Criminal Appeals, and in between the time that our previous panel had decided the case and the time it gets to the Court of Criminal Appeals, the Court of Criminal Appeals had decided a different case that had an impact on that case. And so the Court of Criminal Appeals said, okay, in light of our ruling in X, we're going to vacate the Court of Appeals judgment, and we want you to re-examine it in light of this case that we come down with recently. The only problem is that, they said, we want you to examine it based upon the appropriate rule of harm. Okay? Now, what that means is, just because the trial judge makes a mistake doesn't mean it gets reversed. The mistake has to be something which causes a wrong judgment. It's called a rendition of an improper judgment. Okay? There can be lots of mistakes that can happen during a case. It doesn't mean that they're bad enough to reverse it. Sometimes called the harmless error rule. And so it comes back to us, okay? It's a totally different 3-judge panel than from the first time. Okay? And so the first question is, can we agree on what the harm rule is? Well, the three of us couldn't reach an agreement on what we thought the proper standard was to make a decision. Two of us agreed on the result, but for different reasons. Okay? So being the presumptive author, I got to write the, quote, majority opinion, which was to do X, in that case was to reverse the trial court. One judge thought the trial court ought to be affirmed regardless, and then one judge, the one who agreed with me on the result, wrote a concurring opinion, which means I agree with the court's result. I don't necessarily agree with the reason why. Okay? So I had the majority opinion, he wrote the concurring opinion, and then we had a dissenting opinion. And we all knew that was going to wind up back in the Court of Criminal Appeals, and it's back in the Court of Criminal Appeals. We'll see what they do with it. Sometimes you get to the point where, especially with a situation like that where there's brand new law on something from the high court, and those of us on the intermediate level can't exactly figure out what it is we're supposed to do. And so that's how the process works, is we use our best judgment and we make our decision. And if the folks upstairs want to tell us that we need to be thinking a different way, then they can tell us we need to be thinking a different way. But that's how that works. There are other types of cases other than appeals, and probably the one which is most frequent is called a petition for a writ of mandamus. So what does that mean? There are certain things, certain decisions that trial judges make that have to be addressed now, because if the parties follow their ruling, the cat's out of the bag, and there's no way to put the cat back in the bag. Okay? And so the best one, for example, let's say you and your lawyer had a discussion about something. Okay? And that's going to be privileged, generally speaking, by the attorney-client privilege. That is a very sacrosanct privilege that the law recognizes, that people have to be candid with their lawyers. Okay? And you need to. It's just the lawyer can't do his or her job if they can't get to the very crux of the matter with their clients. So let's say we have a judge who thinks that that there's an exception to the attorney-client privilege which applies to this case, okay? And he orders that the lawyer testify about what or orders the client to testify about what they told the lawyer. Well, if that's allowed to happen, once the other side finds out, there's no way you can unfind it, okay? It's out, okay? That's why something has to be done now, okay? And so that's the type of thing that a mandamus is designed to address, okay? Even though there's no judgment, even though there's no statute, okay? It's something that the common law provides based upon how the system ought to work, okay? And so, remember I said we have lots of panels? Okay, one of the panels that we have are what we call the original motions panel, okay? And that covers mandamuses. And so we have rotating panels for that, okay? And so when those come in, we look at those on an urgent basis because they're, generally speaking, something that needs to take priority over what's going on in the usual course of events. And so we look at it, and sometimes we look at it and just say, there's nothing here, okay? And we dismiss it. Sometimes we say, okay, there may be something here, and we ask for a response on an expedited basis, okay? Then so that's when the other side has a few days to write their response and send it to us. And so once we get the response, we then do that reviewing the record, reviewing the law, studying. We don't generally have oral arguments on mandamus. Once in a blue moon we do. And then we render a decision on that, okay, based upon whether or not, based upon that record that we see, the trial judge, as we say, abused his discretion. That's a technical term, but that's how we look at it. And then if we don't entertain it, then it can go to the Supreme Court for them to decide whether or not the trial judge abused the discretion or not. So anyhow, that's kind of the bulk of the work that we do. Now, once that 3-judge panel writes its opinion, it then gets circulated to the other 4 judges just so that they can see it. I mean, sometimes, somebody amongst the other 4 will say, no, wait a minute, did you think about this? Or they'll say, well, the Supreme Court just came down with an opinion which you may want to think about. So it's good to have the input. They don't get a vote on it, okay? But they can tell us things that they think that we may need to reconsider, okay? And once that's called the non-panel review. And once we're finished with the non-panel review, that's when the opinion gets released to the parties and to the public as to what our decision is. Then, of course, if somebody is unhappy, which they, the ones who didn't get what they wanted usually are unhappy, they have the right to file a motion for rehearing. And the first thing they do is they file a motion for rehearing with the 3-judge panel that made the decision. And if we, as is statistically the usual result is it's denied, then they can file what's called a request for an en banc, or all 7 judges to reconsider it. And sometimes that happens. It's very unusual, but it has been known to happen. And then you get all 7 judges, and on a really rare occasion, you get all 7 judges in the courtroom for oral argument on a motion for rehearing en banc. And so those are the cases which generally have, it's usually a lot of legal disagreement among the judges as to how the law should be interpreted. And so it's, again, there are times when the law is very clear. There are times when the law is very muddy. And so the muddier it gets, the more likely it is you're going to have people with differing opinions. And so that's how the inner workings of the Court of Appeals works, and that's just the way we do it. How other courts do it, is up to them, and so everybody has their own internal procedures. So that's kind of what we do, how we do it, and I guess you may want to know who the judge is on the court. Oh, and also people, our official title is justice. And that's just the way the law happens to be written. Trial judges are typically known as judges. Unless you're a justice of the peace, then you're a justice. And there's a funny saying, because on the Texas Supreme Court, their titles are justice. On the Court of Criminal Appeals, their title is judge. And so you'll hear a little, joke occasionally that there are no judges on the Supreme Court and there's no justice at the Court of Criminal Appeals. So, anybody got any questions? Yeah. We have the front and the back. We'll start in the front.
During your research, do you ever read the trial record?
Oh, absolutely, absolutely, and that's what's been interesting is the result, what the pandemic has done to the type of work that we have. Before the pandemic, we had lots of jury trials. If you're on the civil side, you have jury trials in your workload, you have judge trials in your workload, and you have all this preliminary stuff like those injunctions, which aren't jury trials, but they're based upon hearings in front of the court. And those all come into us from the civil side. On the criminal side, there's really, there's not a whole lot that comes to us from the criminal side except for jury trials, okay? Because they don't have all that. They don't have all that procedural stuff for the most part, like the civil courts do. When the pandemic hit, all the jury trials stopped, okay, for a long time. And so instead of having, it's easier to visualize this going back the way the record used to look before computers, okay? So if you had, let's say, a 6-week medical malpractice trial, I could fill up the table this high with what the trial record would look like, okay? I mean, it was volumes and volumes and volumes of testimony that we would have to read. Criminal cases, except for capital murder cases, criminal cases tend to be shorter, so you'd have this much instead of all of that. But it was still a lot of reading from the trial court, okay? Because there weren't jury trials going on, and really not many bench trials going on, which are judge trials. The volume of the number of cases didn't go down that much, especially on the civil side, but the type of record changed a whole lot. So it turned into just a totally different type of review. Now that we're coming out of the pandemic and we're seeing more jury trials, we're getting back into the lengthier records. Certainly on the civil side, the criminal side still hadn't caught up with it yet. But but yeah, I mean, we have to. I mean, a lot of what we do are what are called sufficiency of the evidence review, okay? And so if we don't read the record, we don't know what the evidence shows. So we have to read through it and analyze it so that we can see what the parties are complaining about. Yes, sir?
Are there restrictions on how long you can serve?
For Court of Appeals and Supreme Court, I was going to say for all appellate court justices and judges, we can serve till age 75. If we hit age 75 before the end of our 4th year, we age out at the end of the 4th year. If we turn 75 after, in other words, year 5 and 6, we can finish out our term. Okay? If you're on the district court bench, then if you turn 75, if I remember this correctly, you can finish out your term, because those are only 4-year terms, not 6-year terms. If you're a county court judge, there's no age limit. So one of the things that's going on in the legislature right now are some bills to address that question. And so as is oftentimes the case, the impetus comes from the Chief Justice of the Supreme Court and the Chief Judge of the Court of Criminal Appeals are both approaching those age-out requirements. So the legislature is looking at increasing the age. Well, one bill would do away with it completely, and another bill would move it from 75 to 79. So, but again, in the county, and when I say there's no limit in the county, that's Tarrant County. I mean, every county will create their own rules. So, yes.
So with the population growth that we're having in Texas, I
Yes.
mean, are we having to expand the courts to address the more population that we have, or is it still being filtered in what we have?
Good question, because I'm trying to think what the date. We have had, in terms of the appellate court judges on the courts of appeals, we've had 80. Okay, realize that we have over 1,000 trial court judges. Okay, well over 1,000 trial court judges. The next step up, which is us on the Court of Appeals, there's only 80 of us in the entire state, and that's all we've had for a long time. Okay, now what they've done, and so I can't remember the last time anyone added a position. It's been a long time. So we addressed that through efficiency. Okay, by computerizing and doing all that, we've made our ability to handle more cases through efficiency. We use, depending on what court you're in, what we do is we have professional, you've probably heard the term briefing clerks or briefing attorneys. Okay. Some courts, the historical approach was for courts to have young lawyers who are coming out of law school work for them for a couple of years as briefing clerks, and they would work for the judges. We don't do that, and it's been a while, and it's long before I came onto the court. We use professional staff attorneys. So it's people, my staff attorney has been with the court for 14 years, I think. And so, she's very good at what she does, and we have a number of them who've had that kind of longevity, and they're very good at with the rules and the procedures. They're very good at reviewing the record, and how the staff briefing attorneys interact in terms of writing opinions and they don't make decisions, but obviously we consult with them and we use them greatly in terms of how we do it in each chambers. Okay, each judge is referred to as a chambers. Okay, and then you have your staff in your chambers. How you function within those roles varies from one chambers to another. Yes.
You're in the business of making opinions and rulings.
Correct.
In your opinion, do you think that judges at the various levels, state and federal elected officials, have any more or less impact on people's lives and well-being as do airline pilots who have very strict age limit requirements?
I think that as far as airline pilots are concerned, an age issue at any given moment could wind up in 200 or 300 people dying. And that's something which is a different situation than what we have to deal with. I think that, there are some judges who some would argue should be on the bench at age 50, are age 35, okay? And then you have judges who are in their 80s, okay, who are every bit as good and maybe in their prime as opposed to someone who's not. And the good thing about our system, and it varies from county to county and district to district, but the voters get a chance to decide that issue, okay? And it's pretty rare, in my experience, that you have judges who, because of their age, aren't able to do their job unless there's something like, unless they've had a stroke and you actually have mental disability, okay? That's a different situation. And I've never seen anyone try to stay on the court who has had a mental incapacity. And there are ways to deal with that. And there are ways to deal with people who shouldn't be on the court either because they don't have the mental capacity, intellectual capacity to do it. They don't have the proper demeanor. And that really has been the sort of thing I've seen people respond to more than anything else. And it's usually on trial judges who have just established over a period of time that they simply just don't have the demeanor to be a good trial judge. And at some point in time, those circumstances, even in Tarrant County, you've seen the bar, or not the bar officially, but the lawyers in the community work to get things done to get them unelected, so to speak. And so it may take a while, and that's not always, you may wish you had a quicker way of getting things done, but you can't make a decision about whether someone's temperament is good based on one decision. It's the sort of thing that they need to demonstrate over a period of time. So, if you're living in Jones County, Texas, which is Anson, okay, everybody in Jones County knows the judge, and the judge knows everybody in Jones County, and so the electoral process there is very direct. And if somebody sees something that needs to be done, they can usually do it in a relatively short period of time. If you're in Dallas County or Harris County, it's more difficult because, it's in those situations where you have one-party counties, your ability to deal with that's going to be through the primaries, not through the general election. It was interesting when Dallas shifted from dominant Republican to dominant Democrat, literally in one cycle, okay? There were a lot of people who were running on the Democratic side who didn't have much experience, if any, as trial lawyers. And so they wound up in a position where they really didn't have a lot of experience that would help them be good trial judges. And over time, in the democratic process in Dallas, they weeded through people, and so they've gotten used to that in the Democratic primaries in Dallas and dealing with that situation. And I think, in Tarrant County, we've been very blessed for a long time. In fact, if you talk to most of the lawyers who try cases in the North Texas area, they love being in Tarrant County because we have good trial judges. Our clerks are there to help people and not to hinder people, and it's a great place to try to get through the administration of justice. Okay, which doesn't mean we haven't had our exception every now and then over the time, but as a whole, Tarrant County is generally seen by people involved in trial work as a great place to be. So yeah, there's no perfect system. If you get into an appointed system like a lot of states have, first off, there's politics involved in an appointed system. So everything in life has politics. So the question is, which politics do you want? Do you want the part that you get to vote for and participate in, or do you want the one that the politics is all handled by somebody else? And so it's just, every system has its drawbacks, and we, like everything else in life, we deal with as humans, we do the best we can.
Is your salary and the expenses of the court paid by the state?
I had two sources. Okay, the county can add a supplement which brings it up to a certain point, and so we have it's called the county supplement. So I don't know what the percentage is, but the big chunk of it comes from the state, and there's a little chunk that comes from the county. So that's why I get to wear a county badge, and I get a little bit of county benefits and a little bit of county check.
Does each justice have their own personal staff?
The way we work, okay? Let's go back to 2019 when I first started on the court. My staff consisted of me. I had 2 staff attorneys and 1 paralegal who I shared with another justice. And each chambers was set up the same way. We had a budget issue that year, and so to deal with a budget shortfall with the state of Texas, we lost, I think, 2 staff attorneys. And so we recreated our system so that now each justice has 1 full-time staff attorney. I still have the paralegal that I share with another justice, and when we have what's called the central pool of staff attorneys, and the way we handle the workload has changed a little bit by virtue of the fact that we have a central pool that we all share in, plus our own full-time staff attorney that is our right hand. Does that make sense? We're hoping to go back, but legislature, you know how they are. They want to spend money on everybody else but the judges.
Thank you very much.
All right. Well, I'm happy to come out. Anything.
Lunchtime.
Lunchtime. That's important.